Good afternoon. We welcome you to Ethical Considerations in Pro Bono Work with Toby Rothschild, presented by the California Lawyers Association. We hope you enjoy the program and we thank you for joining us today. A PDF copy of today's presentation has been made available to you to print or download. You may access this document by clicking the Resource tab on the left side of the screen. You are encouraged to submit questions at any time throughout the broadcast by selecting the Forum tab, which is on the left side of the screen. Simply type your email address, and your question, and click Submit. Questions will be answered at the end of the program, and questions not addressed within our available time may be answered by way of post-conference email. At this time, I'm happy to introduce your presenter, Toby J. Rothschild. Toby J. Rothschild is of Counsel of One Justice, providing ethics, training, and counseling to legal services programs in California. He retired after serving as the General Counsel of the Legal Aid Foundation of Los Angeles for 13 years. Prior to that, he was the Executive Director of the Legal Aid Foundation of Long Beach for 28 years and Interim Executive Director of LAFLA. He graduated from the UCLA School of Law in 1969 and has worked at legal aid programs since graduation. He has been the president of the Long Beach Bar Association and was vice chair of the California Commission on Access to Justice. At this time, it is our pleasure to turn the program over to your presenter. Please begin.
Thank you, and welcome to learning about ethical issues in working with pro bono clients. To start with, there's not that much difference often, but the people are different sometimes, but a lot of the ethical issues are really the same. They just play out in slightly different ways. So let's get into it. The agenda for today, we're going to talk about what is pro bono. Actually, we're going to switch the first two around. We're going to talk about why you ought to do pro bono first, and then we're going to put in the definition, talk about what it is. We'll talk about who the lawyer in the case is and who the client is. We'll talk about the scope of work that you're doing. We'll talk about the duties to the client. Talk about special issues that arise, sometimes more so in pro bono work than in other kinds of work. And we'll have a minute or two to talk about working with nonprofit organizations, which sometimes have some different issues than normal business working with organizations. And then we have some not so hypothetical hypotheticals that we will work through to show how some of this applies in the real world. So, why should you do pro bono? Well, let's start with some of the ethical reasons. Rule 1.0 of the California Rules of Professional Conduct in Comment 5 says a lawyer as a member of the legal profession is an officer of the legal system and a public citizen having special responsibilities for the quality of justice. The comment goes on to talk about how lawyers should perform pro bono services at least 50 hours a year and should make every effort to make the large majority of those hours working for low-income people or organizations that work with low-income people. Before that, even before the rules had that, it was in the statutes, in the State Bar Act, in Section 6068 of the Business Professions Code. It says it is the duty of a lawyer never to reject for any consideration personal to him or herself the cause of the defenseless and the oppressed. Now, I don't know that anybody has ever been disciplined for violating that statute, but it has been discussed in cases and it is clearly spelled out as an obligation of lawyers to do that. But there's some other reasons why you ought to do it. 70% of all civil cases have at least one party unrepresented. On average, each low-income family faced 4 legal problems each year, and only 27% received any legal help. Clearly, there is an enormous need for assistance, not just in civil cases, but in other matters too, but overwhelmingly in civil cases. What are some of the other reasons people should do pro bono? They get excellent training. They get experience that may be much faster than they would get it working in a firm. They make excellent contacts with lawyers and judges that like the fact they're doing pro bono work. That gives you a badge of honor in relationships with judges and lawyers. And it gives you some worthwhile work that people often feel very good about having done. So what do we mean when we talk about pro bono? So the definition is, and I think this is in the rule, it's certainly in ABA Model Rule 1.6, which the California comment that we talked about was adapted from. It's the direct delivery of legal services without expectation of compensation to indigent individuals or to not-for-profit organizations whose primary purpose is services to the poor and disadvantaged. So let's break that down. Direct delivery of legal services. That means it's actually practicing law, not serving on a board, not building houses for humanity, Habitat for Humanity, not serving in a soup kitchen. All of those are very worthwhile things, but they're not pro bono work because pro bono is direct delivery of legal services without expectation of compensation. So it doesn't include the fact that your client stiffed you. That's not pro bono. Court-awarded fees, generally, if it's the kind of case that you take because there's court-awarded fees and you expect to recover your fees that way, that's not pro bono. Sometimes some public interest kind of work where the fees may be very iffy, if at all, can be considered pro bono. To indigent clients or not-for-profit organizations, we're looking here, so it's not representing the symphony or the museum. It's representing indigent individuals. It's not-for-profit organizations whose primary purpose is services to the poor or disadvantaged. We're looking at a limited set of what might be called pro bono for the purposes of today's program. So when you start up on a case, the question is, who's the lawyer that's actually in charge of the case? Is it a solo practitioner or small firm lawyer? Is it an associate at a firm? Is it a partner? Is the legal services lawyer the lead and the pro bono lawyer working with them? Are the two co-counsel? It's really important up front to define the role of each. You need to say who has primary responsibility. Where did the case originate? Did it start at the legal aid program or the pro bono project, or did it come into to you in some other way? I would urge that it's very important to use legal aid or pro bono programs to obtain pro bono cases. Why is that so important? Because the program will screen the clients, make sure, number one, that they qualify, and number two, that they have a case that's worth pursuing. They provide backup and support during the handling of the case. They provide first dollar malpractice coverage, so it covers even if you don't have coverage, or it covers in front of your coverage if you do have coverage. So lots of other reasons, but those are three of the major ones why it's important to use a legal aid or pro bono program to get your pro bono cases. Look at, does the program, if you did go through a legal aid or pro bono project, do they still have a role? Are they providing backup? Are they providing co-counsel? Are they providing training? Usually they will provide some training if it's an area you're not familiar with. Do they provide a way for the client-attorney relationship with you to be mediated? So if you have a problem with the client, the program may be able to help mediate that. Or if the client has a problem with you, they may be able to help resolve that issue. So again, important to use the legal aid program, understand up front what the role of the program is as you go forward. So you figured out your role and how that plays with the other lawyers involved in the case. So now we're going to look at some of the things you need to understand in that. Who do you go to with problems? If you have a problem with the substance of the case, with the law, who do you deal with? Somebody in your firm? Somebody that is knowledgeable about the substance? You go back to the legal aid program. If you have a problem with the client, we talked about having a legal aid or pro bono project available makes that much easier. If you have an ethics or potential malpractice problem, where do you go? Do you go to your firm, to somebody in your firm who's the general counsel or designated person to deal with ethics issues? Do you go back to the legal aid case and get consulting with them? Virtually all the legal aid and pro bono programs in California do have outside ethics counsel, me. So I'm available to them to provide that kind of backup and support that can then be passed on to you. At the end of the case, if you have a legal aid program or pro bono project, it's important to notify them of what you did and the outcome, and that the case is over, so they can close it on their records, so they have the statistics that they can use for their fundraising, for their grant reporting, other things like that they need. Okay, so you're settled away now in what your role is and what you're going to do. Who's the client? Generally, it's probably an individual, but there are issues that arise. Even if it's an individual, sometimes there's a question of child is the one who has the injury or the issue, but is it the parent or the child that's actually the client? It's probably a legal issue that may depend. Do you have a conservator? Do you have a guardian ad litem? Or do you need a guardian ad litem if, for example, it's a child and you need somebody to be appointed to oversee that case? If it's a couple or a group, you really need, anytime there's more than one client, you have possible conflicts. You need a full disclosure and consent. So under the new conflicts rules, that went into effect a year ago, under Rule 1.7, the question is there a substantial risk of a material limitation on your services? And virtually any time that you have more than one client, you're going to have that risk. And you need to know up front, and you need to explain to the client what the risks are and what the likely outcomes are if there is a conflict that arises down the road. You need to tell them, what do they do? You have to address things like privilege issues, the fact that there isn't, anything you discuss is privileged to the rest of the world, it's not privileged between them. So anything one of them tells you, you can be compelled to tell the other if there's ever litigation between them. Confidentiality is something that one of them tells you, can you keep that confidential from the other? We'll talk about that a little later. What if they have different desires, different interests in the outcome of the case at some point? All of those things need to be discussed up front and signed off by both sides if you're going to continue to represent both or more than one. Sometimes it's larger numbers. Also, anytime you have more than one client, beware of something called the aggregate settlement rule, Rule 1.8.7, which deals with how you divide things up and how you agree to settle when there's more than one client and an offer is made to settle everything as one. So, what am I doing? We're going to talk about scope of work. We'll get to that one in a minute. No, let's do it now. So, scope of work, model rule, or California Rules of Professional Conduct, Rule 1.2, and A and C. Rule 1.2A basically lays out what the rules are, and this applies in any case, for who has responsibility for what decisions. Client makes decisions about many ways about how the case should proceed. Lawyers can make the tactical decisions along the way, but the rule spells that out for you. Settlements, it's very clear. The client makes the decision no matter what. Section C talks about limited scope representation. It talks about how you can limit the scope of the representation. That can be anything from I'm only providing brief advice and counsel, to I'm doing the trial, I'm representing you, but I'm not going to, if it gets that far, I'm not going to deal with collections or appeals or any post-judgment matters. Any of that is a limit on the scope of your representation. Under 1.2c, you have to spell out what the limits are to the client. They must be reasonable, and the client must give informed consent. The retainer or engagement letter that you sign needs to be very clear. It needs to be understandable to the client. It needs to clearly define what you're doing. It needs to define what the limits are on what you're doing. And we'll talk more about that later. And most importantly, once you set those limits, you need to stay within them. Definitely, we'll talk more about that one later. So, what duties do you owe to a pro bono client? Pretty much the same as any other client. You have a duty of competence, Rule 1.1, and diligence, Rule 1.3. You must treat pro bono clients just like you treat paying clients. You must have the knowledge and skill to handle the case and be able to do it that way. But when I talk about diligence, there's a case, California Supreme Court case, where a lawyer was suspended for 3 years because he put off pro bono work to do his fee-paying work. There was one dissent on that. One of the Chief Justice at the time would have extended the suspension much longer. So how do you get that knowledge and skill if you don't already have it in the area of practice that you're involved with? Very often, the legal services program or pro bono program will provide training. There are a number, in fact, of videos that are available to the programs to provide to you on training on how to handle various kinds of cases. And they all include MCLE credit. You can co-counsel with either the legal services program or some other lawyer that does have the knowledge. As you go along, you get backup from the program or from your firm if they have the knowledge of how to do this. You owe a duty of confidentiality under Rule 1.6. Again, no different from any other client, but where it often comes up as a problem is when the client brings a friend or family member with them to help provide support or to interpret what's being said, or you need an interpreter generally. You need to look at, is that a waiver of privilege or confidentiality? Are you allowed to have anybody else in the room? Privilege statute talks about you can have another person involved if it is necessary to assist the client with the matter. So is it somebody that they would like to have there, or is it somebody that really is necessary for them to adequately present their case to you so that you can represent them? Interpreters, and we'll talk about interpreters later because they raise lots of other issues. Loyalty, conflicts of interest, rules 1.7, 1.9. Beware of conflicts. It's often not a problem in legal services and pro bono work. But if you're solo or small firm or in a small town, it may be that you have a conflict with the other side in the case or some previous client. If you practice in the same substantive area, if you represent landlords in eviction cases, you may not want to represent a tenant in a pro bono case. You may want to look for some other case, other field of law to work in. There is one exception to my earlier comment that it's really the same as as fee-paying clients, and that is Rule 6.5. Rule 6.5 says that if you're participating in a clinic run by a legal aid program or a pro bono project or a court or a bar association or those kinds of groups, a law school, that they have a different standard for conflicts. They have what they call a visual conflict rule. That is, if you personally are aware that you have a conflict while you're sitting there at the clinic, then you have a conflict. If you're aware that your firm, that you have an imputed conflict because of your firm, then you have a conflict. Otherwise, you can proceed at that clinic with the counsel advice assistance that is provided by that clinic. Now, it's important that you only can provide that service at that clinic. You can't take it back with you to the office or provide ongoing assistance. As soon as you're doing work beyond the clinic, you need to do a full conflict check and the like. That rule was really put in California because during the foreclosure crisis, it was very difficult to get any of the lawyers from the big firms to be able to assist at a clinic that assisted with home ownership issues, because they didn't know if they had some lender in the transaction, maybe a hidden lender somewhere, that would turn out to be a conflict. And they said, to that lawyer to do it without a Rule 6.5, they have to say, hello, client, nice to meet you. Now, I'll go run my international law firm conflict check and come back in 2 weeks, and I'll let you know if I can help you. That wasn't particularly useful. So 6.5 was adopted. It had previously been adopted by the ABA, and now we have that rule, and it applies to any kind of short-term advice kind of brief service kind of clinic that's run by one of those various types of organizations. So some special issues that we do need to address that are more problematic in the pro bono context. Cultural competence. We're going to talk a lot about that. Why? The role of culture in your perceptions, values, attitudes, and beliefs, and the clients in the response to the environment and the circumstances you're under, in both client and lawyer expectations, in external behavior, and in understanding the court system and procedures. All of those play a role in how you relate to the client and how the client relates to you, and they're important to deal with. So one of the issues that becomes major importance is communication. Looking at empathy, language, specific target challenges around documents, expectations, safety. We'll talk about each of those. So the communications rule, primary rule, is Rule 1.4 in California. And it basically says that you've got to keep the client advised of significant developments in their case. You have to provide them enough information to make a reasoned decision on any issue, which under 1.2a that we talked about is up to the client to make the decision. So you need to make sure you can do those things. If the client is non-English speaking, you need an interpreter. The problem with interpreters, where you run into problems, is often the client will bring with them somebody, a family member or friend, who is able to assist with that function. That's not a good idea. It's much better to use a professional interpreter. The problem with using a friend or family member are several. First of all, how competent are they in both languages? Number two, do you really want the 13-year-old daughter to be translating for her mother in the domestic violence case, describing what dad did to mom? There's lots of reasons why it's not good. In addition, a trained interpreter understands their role being to say exactly what you say to the client and exactly what the client says to you. Anybody who's dealt with non-professional interpreters understands that what's going to happen is you ask a question, the interpreter says something to the client, they carry on a conversation for a minute or minute and a half, and then the interpreter comes back and says, she said yes. That doesn't work. You need to know everything that you say is being told to the client, and everything the client says is being told to you. So you've got that issue that you need a professional interpreter. Keep in mind, it's not just non-English speaking people, it's also sign language. It may be the language you need to interpret if the client is unable to communicate, unable to hear, you may need a sign language interpreter. If the person is limited English, you may need to use simple words to try to make sure that they understand. If they're limited English, it still might be better, depending on how limited it is, to use an interpreter. If they're not literate at all, keep in mind that when you have documents that you're showing them, particularly your engagement agreement, you need to read it and go over it so that they understand it. In fact, I would posit that you need to read and go over particularly the engagement agreement every time. You want to make sure the client understands anything in it, what their obligations are to keep you advised of their address and so forth, to understand what you're doing for them and what you're not doing for them, maybe more importantly. And that needs to be done in a way that you're confident that they understand it. Understand that if you need documents from clients, they may not have or may never have had those documents, and you may need to be the one to try to get them for them. And again, you may need to read and explain your documents to the client. Expectations, that's a biggie. You have certain expectations of the client. They have expectations of you and of their case. You need to make sure that they understand what you're willing to do and what you're not going to do. You need to make sure they understand what you can do in terms of the ability of what the potential outcomes might be, so that they aren't believing that they have some massive outcome or that they have no chance at all if they really do. But you also need to understand the client's expectations and that they and their needs. I had a case where the client was in a situation to get a substantial amount of money in a settlement if the case was trial was to be avoided. The client could not accept the money because it would have taken them off of Medi-Cal and SSI, and they needed that to continue to live. So money wasn't at issue in the case. It was possession of her home, and there was no way that we could agree for the landlord to be able to buy out that tenant. But if you don't ask the questions, you're never going to know that. Keep in mind that it takes time to build trust with a client. You need to work patiently with them. At first, they may tell you what they think you want to hear. You need to spend the time to build that trust, explain to them issues around privilege and confidentiality, what it really means, and how important it is for them to communicate openly with you. You need to set clear boundaries on communication and stick with them gently but firmly. So you need to tell the client, don't call me every time something minor happens. Let's set up a time once a week where you'll call just to check in, or here's the kinds of things I want you to call me about, and I need you to check in because I can't always reach you. They may not have a cell phone. They may be out of minutes on their cell phone or out of battery. They may not have an address that they can be reached at, or they may move often. It may not be safe to communicate with them. If you're calling them at home, say it's a domestic violence case, you can't exactly leave a message on an answering machine if the victim is still living with their alleged abuser. So you need to be very careful to discuss things like that. Is there someone else that you can have a name and phone number of that will always know where the client is and how to reach them, so that you can contact that person if you can't find the client? Things like that are important to have in that initial discussion as you move forward. So we talked a minute ago that we mentioned that empathy is one of the things. Empathy has to do with perspective taking, thinking, how does this appear to them? What's their perspective of this case, so that I understand where they're coming from. Staying out of judgment, recognizing emotion in other people, and communicating that you recognize it. I understand this is very upsetting for you. How can we make it easier for you so that we can have our conversation? Things you can do that can keep the conversation going, but letting them know that you see what's going on with them and that you understand it. Resist the temptation to advise the client what to do. Give them options instead of telling them what to do. Let's see, we already talked about that. So let's go on to talked about documents, expectations, time and transportation. Keep in mind that when you're working with a low-income client, a 9 o'clock appointment may not work because they have to get the kids to school, they have to get to work. You need to work around their schedule. It may take 3 buses to get to your office, and therefore, having a tight schedule of when they're going to come see you may not be the best idea. Think about the location of the meeting. How long is it going to take them to get to where that location is? If you're in a high-rise office building, there may be intimidation of that for them. They may have a fear of elevators, particularly if it's a high floor. If you're in a building that has security, they may not have the kind of ID they need even to get into the building. So if it's possible and works for you, try to meet somewhere else if the client is more comfortable. But beware of privacy issues. Don't meet at Starbucks or at the local coffee shop because you don't know who's sitting at the next table. So it needs to be a safe and secure location if you are going to meet outside of your office. Dress. The client may not have court clothes. It's possible that the client will not have the kind of clothes that you would expect for them to wear to your office or to court. We'll talk later about some things that might be done about that. Also, be sure that your dress is appropriate. Keep in mind, the client is not looking for a friend, they're looking for a real lawyer. So you need to look like a real lawyer. Now, I know that means something different now than it did 20 years ago when that meant always having a coat and tie, but they want somebody that they know is working for them and is a real lawyer. Be sure to return phone calls, respond promptly. If they are abusing how often they call you, make sure you have that conversation with them. And maybe you only return the calls once a day or every 3 days or whatever works for the nature of the problem. The scope of the work. I've mentioned this a couple of times, but this is really important. Make sure it's clear in the retainer exactly what you intend to do and what you don't intend to do. I'm going to represent you in this dissolution of marriage case. I will deal with the status of marriage, and I will deal with custody issues and support issues, but I will not deal with divvying up the knives and spoons. Or I will only deal with one aspect of the case, or I will represent you at this hearing, but not at anything beyond this hearing. All those things are permissible under the rules, but you need to make sure the client understands which things you're doing and which you're not. If you are doing a limited scope representation, there are court rules and forms in the California Rules of Court that you can lay out what you're doing and what you're not to know, so that both the judge and the opposing counsel know that if you're only doing a limited piece of the work and they have an issue with some other part of the work, that they contact the client directly. You need to clarify in that retainer the future contacts, how you're going to deal with each other. We talked about that before. And they say here that there's a malpractice risk if you don't do it right. I'm aware of several cases where the attorney agreed to a limited scope of work, completed that limited scope of work. The client returned for additional work on the same matter, and the lawyer helped them with it. And maybe they helped them with the next piece, but then they didn't continue. In one case, I know of a 7-figure jury verdict against, on a pro bono case that was because the lawyer didn't stop when they said they would, and therefore became attorney of record for the entire case. On the future contacts issue, once the case is done, you need to communicate that the case is done. You need to communicate that I've completed the work that I said I was going to do. I'm no longer your lawyer for this case or for any other case. I'm not the lawyer for your friends and neighbors and your family. If they have problems, if you have new problems, or if you want to continue this problem, this matter, go back through the agency that sent you here, and they may send you to me, they may send you somewhere else, or they may not be able to help you, but I can't go further on this case than I've already agreed to do. If you do decide that you want to go further, the critical thing is to get a new retainer agreement, a new engagement agreement that says, now I agree to do this next step and no more. But make sure that you're always defining how far you're willing to go. Okay, so if you're dealing with organizational clients, the question comes up, what is the legal status of the organization? This is Rule 1.13 in the Rules of Professional Conduct. Often you're dealing with an unincorporated association or a loose group of people who maybe want to form a nonprofit or who have some issue that they want to take up as a group, even though they're not incorporated or in any kind of way a formal group. What's critical to know is who speaks for the organization. Once you know the status, who is it that you're supposed to work with? You need to clarify with everyone that you represent the organization and not the individuals in the organization. And you need to understand if you have a problem with the person that you're dealing with under Rule 1.13, you have an obligation then to go up the ladder, up the chain of command. So if you're dealing with the vice president, because that's the person that's been assigned to work with you on the case, and you think that that person is leading the corporation or the organization astray, you can go to the president. If that person, again, continues, you can go to the board of directors. If you can't get that issue resolved, you have the option or maybe the obligation, depending on the circumstances, to withdraw from the case. So it's really important that you work with the organization and understand how it functions so that you're sure to get it resolved. I was involved with one case with a nonprofit. The person I was working with was doing something that I felt was illegal and could cause serious problems for the corporation. I went to the board. The board agreed with the executive director of the organization that they should proceed that way, and I withdrew from the case. Part of the problem was that they were blaming my advice for what they were doing, but they have, they went on and did it anyway. So let's look at some non-hypothetical hypotheticals. All of these are based on actual cases. So pro bono attorney A agrees to represent husband and wife in an eviction proceeding. 3 days after A files the response in court, the couple notifies him that they have separated and H has moved out of the apartment. H wants to settle the case with a waiver of the back rent owed. W wants to stay in the apartment. What steps can A take to address the situation? Take a second to think about it. So, number of issues that should be discussed with and agreed by all the clients when representing more than one client in the same case. If you recall at the beginning, I said that anytime you have more than one client, you've got potential conflicts and you need to go through that process of explaining all the options and the risks of representing both. I used to think that, what's the big deal? You've got a husband and wife in an eviction, they're living together, everything's fine. The case, from the time you file an answer to the time the case is over, is less than 30 days generally. What's the problem? Well, the problem is this, and it does happen. So you need to advise them of the potential conflict. Clients may have different desired outcomes or give different instructions to the attorney. There's the possible aggregate settlement, and that's an error that should be 1.8.7. California used a different numbering system. That's the ABA number. But it's 1.8.7. The issues that we mentioned about confidentiality and privilege. Communications with one client may not be confidential from the other client because you may have a duty to disclose significant developments in the case. And the clients need to understand that if a problem does arise, you may have to withdraw from both clients as the case goes on. If the conflict discussion is not held in advance, the attorney can try to convince the clients to work something out, or it's possible for one client to consent to the conflict and allow the attorney to represent the other. Otherwise, they have to withdraw from both. It's not necessarily that you can do that representing one with the other's consent. Sometimes even that doesn't work. So, hypothetical number 2. Volunteer represents Mrs. R in an eviction defense on a pro bono basis. She's indigent and lives in federally subsidized apartment with 3 children. If she's evicted, she'll lose her subsidy and probably become homeless. She owes the landlord $450. Can the firm cover copying costs, transporting her to and from the court and the law firm? Can the firm cover the rent arrearages? Take a minute and we will let you think about it. Okay. So again, this is a typo from the ABA rules. It's 1.8.5. Prohibits financial assistance to a client in connection with litigation. There's an exception that permits paying court costs and litigation expenses for an indigent client. To give you more specifically what the rule says, it says that you can pay the costs of prosecuting or defending a claim or action, or otherwise protecting or promoting the interests of an indigent client in a matter in which the lawyer represents the client. It's fairly broadly worded, clearly would cover copying costs, would cover transportation costs, I think would cover, providing a meal if you want the client to have some money to buy a meal so they come to court coherent, and transportation so that they can get there. The rent, I think, is problematic. I think it really is a difficult question as to whether that's within that content of protecting or promoting the interests of the indigent in the matter. And I suppose where I come down is sort of a rule of reason on this. If it's $20 that's at stake, and I've seen cases where evictions have gone ahead for $20, yeah, you probably can do that. If it's $450 or rents the way they are these days, $800 or $2,000, I think that probably is beyond the pale, beyond what's reasonable under that rule, and you probably can't do that. Okay. Going on to number 3, Penelope pro bono attorney signs up to staff a limited scope clinic where she helps Charles' client fill out his petition for guardianship for his nephew. Charles and Penelope get along well, and when Charles asks Penelope if she could go with him to the first court appearance, she wants to say yes. What advice do you have for Penelope? Take a minute. Key issue is the scope of representation. She only agreed to help fill out the petition. If she does more than that, she's at risk of becoming attorney of record for the entire case. Before doing anything more, she should consult with the agency sponsoring the clinic, and if she goes forward, get a new retainer agreement limiting the scope to the first hearing. Also, if it was a Rule 6.5 type clinic, one where she did a visual conflict check, if she's doing anything more than that, she then needs to run a full conflict check back at the office to make sure that there isn't a conflict with the other side in the case. That's really important. Number 4, Barbara and her nephew Albert asked for pro bono representation in a credit card collection case. Both are named in a lawsuit, but neither claims to have an account with the creditor. The attorney accepts both clients. Albert later admits to pro bono attorney that he used Barbara's identity to open the account and charged it up. What are the volunteers' options? So, question, do they have a joint client retainer agreement at the time of the beginning of the case? Does the lawyer have an obligation to tell Barbara what Albert told her? Rule 1.4 requires informing client of significant developments in the matter. Is it a significant development that your co-client, in fact, did sign up for that credit card in your name and forged your name on the account and ran it up and owes the money? Probably is a significant development, and you probably have to inform Barbara of that. Even if Albert says, don't tell my aunt, but can't do that. Can the lawyer to continue representing both? Can the lawyer represent either? It's clear that there's a conflict under Rule 1.7. There is a more than just a substantial risk of a significant impairment, a significant risk of a substantial impairment in your ability to represent the client. You can only continue with informed consent, and since it's unlikely the lawyer can provide competent representation to both, this is not an option. Even if, in this kind of situation, even if they had an agreement, a waiver, a consent to conflicts at the beginning of the case, this is a significant enough actual conflict that you'd have to go back and get a new waiver if you're going to get one. But I don't think this one you could actually get a waiver from both. You could get a waiver possibly from Albert to say, I will withdraw, and I'll substitute you out, you won't represent me, and I can, as now a former client, I consent to your continuing to represent Barbara. And if that is acceptable to them, that makes some sense and might be able to be done. So didn't know how the timing would work, but there's one more topic I wanted to at least address, which I didn't have a slide for, and that's the rule of dealing with clients with significant cognitive disabilities. Many times you'll get a client who is perfectly fine, and then as the case proceeds along, they have a diminished capacity to understand and to communicate with you. The American Bar Association rules have a rule, Rule 1.16, that addresses how the lawyer deals with that. And it starts off with, to the extent possible, you treat the client the same way you would treat any other client. And that's clearly true in California, too. It goes on to provide other rights and remedies for the lawyer in terms of how they deal with that situation. The Rules Revision Commission in California proposed a version of Rule 1.16 that was not nearly as far as the ABA rule. The ABA rule goes so far as to allow the lawyer to file a conservatorship petition against the client's wishes. California never could go that far under our confidentiality rules, but we did have a proposed version of that. Of the all the rules, the 60 rules that the Commission submitted to the Supreme Court for approval, they were all approved except that one. That one was deleted by the Supreme Court. So we don't have a rule on dealing with clients with diminished capacity. What you have to do is figure out, you know that you can't disclose the information without the client's consent. You can't notify the son that there's a problem with your father and he could use some help, or things like that, or partly because you don't know, is the son the good one and the daughter is really the one that's ripping the client off, or whatever. So you can't deal with those issues. You can't disclose it without the client's consent. So the question then is there a way to get client's consent? If you see the client over time losing capacity, you might want to have that discussion with them while they still are able to have that discussion and work with them. You can probably bring in a person to assist you with that, somebody who is professional at dealing with individuals with diminished capacity, a social worker or gerontologist, who can maybe work with that person to get them to understand what the issue is and how they then can proceed to get help. If not, ultimately, the only answer is that you need to withdraw. Because if you can't communicate effectively with the client, you can't get their consent to a settlement, you can't get their answers to interrogatories, there's no way you can effectively represent that client, and your only option, even though we know it leaves the client hanging out there unrepresented, is that you need to withdraw at that point. So let's go over some of what we've talked about. You have the same ethical obligations as for paying clients, except for Rule 6.5. You've got to be culturally competent and non-judgmental. You should go through a recognized legal services provider or pro bono project, and to keep that organization informed of what's going on. Call the legal services provider if there are any problems, and have fun and enjoy the work, because it really is a pleasure to be able to do this kind of work. Most lawyers that do pro bono work find that it's the most rewarding work that they do in their career. And besides, doing pro bono work will make your mother proud. So let's take a look and see if there's any questions. Looks like there aren't any at the moment. If anybody has questions, this would be a good time to chime in, submit them. Let me see. I can see what I can think of to add on to the program here. So, I keep stressing over and over again the importance of the retainer agreement or the engagement agreement, and I said it several times, but it really is the critical function. Okay, looks like we do have a question. Okay, any specific issues on impact cases or larger public benefit cases? Good question. The rules are pretty much the same in impact cases. Again, the client has to control. Where people get into problems on these public benefit cases, impact cases, is a couple of places. One is in dealing with the issue of client's control, and that is you're going along, the client gets offered a settlement. They have the right to say yes or no to that settlement, even if it means that this issue that you've spent 3 years working on to try to get this major impact goes away because the client agrees to a settlement. That's why many public interest cases, there'll be individual clients and an organizational client. Usually the organizational client is more wedded to the cause and willing to stay with it longer. But even there, that can sometimes be a problem. But when that then becomes a problem is when the other side says, okay, I will satisfy your individual clients, all of them fully, but only if the case goes away. If we give up the injunctive relief that you're looking for, you waive attorney's fees, your individual clients will get everything they asked for. Those clients have the right to settle, but you have a problem then because you may have a conflict because your organizational clients may say, no, we're invested in the issue. So now you have to try to work that out, and if you can't, you may have to withdraw because the individual clients are entitled to their settlements, and if the settlement isn't available, you have to address that question. You've got clients with conflicting goals and conflicting interests in settlement. Same is true on any other kind of public benefit kind of cases, where there's a large group of people to be affected, but not all of them are before the court. Class actions, I'll take a step back, are a whole special world. They have different rules on a lot of these things, and the control of the case is much more in the hands of the judge. So settlements have to be approved by the judge. The progress of the case, some issues around discovery, all those things get run through the judge, and the judge has substantial control over how those cases are handled. But if you're talking about non-class actions, maybe group actions, or even an individual action that's aimed at creating an impact. The other issue that often comes up, particularly if it's a group action, I'm thinking of a case where you're representing, say, 8 tenants in a building that are suing the landlord for unhabitable conditions. You have the issue of Rule 1.8.7, the aggregate settlement rule, that says that you have to give notice to all of your clients of the terms of the settlement and how it will affect everybody, and have to get written consent from each client. Now, that's sometimes not a problem, but it is a problem if those 8 clients, half of them don't speak English and they speak 2 different languages. Well, some speak Spanish, some speak Chinese, and they work, and they have different injuries involved. So they have different amounts of harm that you're trying to resolve. So when the landlord's attorney says, okay, here's $10,000 for everybody to solve all the problems. You need to communicate that to the clients, which may mean taking the time to translate it into different languages. You need to explain it to them. You need to get their written consent to the agreement, and that has to include how it's going to get divvied up. Who's going to, and it can't be majority rule. It can't be a steering committee that decides whether to accept it or not. It has to be each individual client making that decision as to whether they are willing to make that settlement, fully understanding what the settlement is and what it does. So that's can be a serious issue, particularly if you're settling on the day of of trial, and the judge is ready to go and the other side's ready to go, and they make you an offer, and you've got to say, okay, I'll take the offer to my clients. We'll come back in a couple of days after we've had a chance to get consent, because I can't call them all. Some of them are at work. They aren't available. I need to translate it into other languages. So that can be a real problem. But the rule is there, and that was considered when the rule was continued into the new rules, and you've got to have that kind of result.
All right, we want to thank you very much, Toby. We also thank each of you for participating in today's program. This concludes Ethical Considerations in Pro Bono Work, presented by the California Lawyers Association. Thank you again for attending. Have a great day, and you may now disconnect.